Hello everyone, my name is Isaac and today I'll be presenting on fixtures and fittings and my advice to Abraham. According to LexisNexis, fixtures and fittings can be respectively be defined as when transferring an interest in land, whether freehold or leasehold. Any fixtures form part of the land and are transferred with it, and any fittings, also known as chattels, do not form part of the land and will not be included. Under the Law of Property Act 1925, Section 62, fixtures are included in a conveyance of land. In understanding the case at hand and in advising Abraham, there are three issues that can be found and as listed on the slides. Firstly, that the paintings and sculptures constitute fixtures or fittings in ascertaining the degree of annexation. Secondly, whether the purpose of annexation involving the paintings and sculptures intended to increase the value of the land or for the better enjoyment of the item annexed. Lastly, is the paintings and sculptures to be included with the purchase of property between Abraham and Brenda? As per the first issue, in which do the paintings and sculptures constitute fixtures or fittings, the paintings can be identified as being a fixture or fitting to the test to determine annexation, which was formulated by Justice Blackburn in the case of Holland and Hodgson. According to Peter Luther, in Fixtures and Chattels, a question of more or less, the distinction between fixtures and fittings is elusive. The case law is neither uniform nor consistent, and the law lacks coherence and clarity. Alfonso M. Sculante, in the Law of Fixtures, Common Law and the Uniform Commercial Code, Part 1, Common Law of Fixtures, has further stated that particular items have at times been held to be fixtures by one court and chattels by another. However, in the aforementioned case, and what can be seen on the slides, Justice Blackburn had formulated a two tests to the degree of annexation and the purpose of annexation in a neat antithesis into a pair of rebuttable presumptions that despite certain articles not being attached to the land, are considered not a part of the land. There are circumstances in which it can be considered to be a part of the land, and that an onus lies in asserting whether such article is deemed not to be a chattel anymore or vice versa. The test to determine annexation mentioned by Justice Blackburn involves the degree of annexation, in which it consists of the extent to which the object is affixed to the land or property. Next, the purpose of annexation, in which the reason why the property has to be affixed to the land or property. In the case of Lay and Taylor is whether on the facts and with respect to the intention of the life intent in putting up the tapestries had been annexed to the land as fixtures, and so passed to the remainder man as part of the freehold, instead of remaining as part of Madame de Falbe's estate. This question called for a close consideration of the common law approach to distinguishing fixtures from chattels. It was held by the House of Lords in favor of the estate of Madame de Falbe. The tapestries were chattels and so remained the rightful property of Madame de Falbe's estate. Similarly, in the case at hand, the paintings from the Victorian era in the Victorian style property bought by Abraham can be identified as chattels. In light of the case of Lay and Taylor, although the tapestries were firmly fixed, it was held as chattels. The paintings in the case of Abraham and Brenda were hung on the wall of the property and could easily be removed. Thus, the paintings in the property would be counted as chattels which are not affixed to the land. Elstone and Morris ruled that a bungalow cannot be removed without destruction, and an annexation determines if a structure is part of the land. A house that cannot be moved without destruction is considered a fixture. However, in the case at hand, the paintings from the Victorian era can be easily removed from the wall without any damages, and in light of the case of Elstone and Morris, would justify that the paintings in Abraham and Brenda's case would amount to fittings. As per identifying whether the sculpture constitute a fixture or fittings, the case of Hemp and Bygrave could be applied to the case between Abraham and Brenda. Hemp bought a house from Bygrave. Prior to finishing, Bygrave took out several bulky garden furniture pieces, including stone urns, a stone statue, and a lead throw. They were all freestanding and held in place solely by their own weight, despite the extreme weight. Hemp maintained that Bygrave had no authority to remove the objects because they were fixtures. In the case of Abraham, the sculptures were made from marble and extremely heavy. The sculptures were removed 6 months later when Abraham had moved into the property. The sculpture was resting on its own weight, and the case does not suggest that the sculpture was attached to the floor, cemented, or in any other forms affixed to the land. Despite the sculpture being heavy in nature, it could still be removed without causing any damages. This aligns with the case of Elliston and Morris, in which the sculptures could be removed without getting destroyed and would render it as a chattel. The case we have at hand could be applied in accordance with TSB and Bolton, in which the court held the bath, lavatory, and bathroom fittings were fixtures, in addition to the kitchen sink and units. The curtains, carpets, light fittings, kitchen appliances such as washing machines, dishwashers, cookers were chattels. The case is significant as it draws a distinction between fittings and fixtures, and how an affixed object may likely deem it as a fixture. As mentioned initially, the paintings were not affixed to the wall and could be easily removed. In addition, and as emphasized before, the sculptures could be removed despite being heavy and without causing any damages. Therefore, in summarizing the first issue, the items consisting of the paintings and sculptures can be identified as fittings, as they, to the degree of annexation, are not affixed to the land, and that it can be removed easily. Hence, the items do not belong to the property upon purchase, despite as they can easily be removed from the property without any damages. The issue is whether the purpose of annexation consists of the paintings and sculptures intended to increase the value of the land or for the better enjoyment of the item annexed. As may seen on the slides, the purpose of annexation needs to be ascertained to whether the annexation was intended to increase the value of the land in which it would deem it as a fixture, or for the better enjoyment of the item annexed, which would render it as fittings. If an object passes the first test regarding the degree of annexation, the first test can be rebutted by the purpose of annexation test. Sean Thomas, in Mortgages, Fixtures, Fittings, and Security over Personal Property, further stated that the purpose of annexation test is central to determining whether the object is affixed to the land. As Abraham had visited the property after Brenda had arranged for it, he noticed that the property was tastefully decorated with exquisite paintings and sculptures from the Victorian era. The paintings and sculptures were seemingly only for the better enjoyment of the item annexed. This is in the same vein as the case of Berkeley and Poulet, in which, according to Lord Justice Scarman, the purpose of annexation is more important than the degree of annexation. The statue and sundials were also positioned for better enjoyment as chattels, and the paintings were mounted for the better enjoyment of them as artworks. Abraham would face challenges to contend that the paintings and sculptures were part of the property upon purchase, based on Dean Court and Gregory, which held that the items like statues, marble, tapestries, and framed pictures could be considered fixtures. In the case of Ray Whaley, tapestries were held to be fixtures because the object of the annexation was to enhance the room. In drawing a nuance, as per the case of Lay and Taylor, tapestries nailed to a wall were held not to be fixtures, but in Ray Whaley, similar objects were held to be fixtures because the object of the annexation was to enhance the room. Taking into account the case of Dean Court and Gregory and the case of Ray Whaley, the paintings and sculptures in the case of Abraham can be argued to be fixtures, as both the items form an integral part of the architectural design. Without the presence of the items, the property would rather be plain and unattractive in the eyes of the potential buyers. Taking into account the property being of Victorian style, the paintings and sculptures are from the same period of time, making it an important part of the property. In addition, with the paintings and sculptures being of high value, it could be said that the paintings and sculptures were intended to increase the value of the land. However, it would be challenging for Abraham to establish this, as it is clear to the case of Berkeley and Poulet that although the items are of high value, it would still be deemed as a fitting. Furthermore, the court in Halliwell and Eastwood remark whether it was for the permanent and substantial improvement of the dwelling, or merely for a temporary purpose, or the more complete enjoyment and use of it as a chattel. In the present case, and in the same vein as Berkeley and Poulet and Halliwell and Eastwood, The paintings and statues were placed to promote potential buyers to purchase the property, and that it was not inclusive with the property upon purchase. Should the objects be included with the purchase of the property, the price of the property should have been substantially higher. Thus, the outcome of the case renders both the objects as chattels, and Brenda had all the rights to remove it from the property. The final issue would be whether the painting and sculpture to be included with the purchase of the property between Abraham and Brenda. As seen in the slides, we are to identify the contractual relations and intentions after ascertaining the degree and purpose of annexation. In the case of Taylor and Hammer, it was held that the paving stones should be returned and relayed. The nature of the agreement was such that a reasonable person would consider that the paving slabs formed part of the land, on the basis that the agreement should be found to include them. The paving slabs were a fixture, and therefore the parties were aware that they should pass with the property. The court ruled that the respondent's concealment and dishonest answers prevented him from using the principle of caveat emptor. This is contrary to Taylor and Hammer, and based on the first and second issue. Both the items are likely to be fittings and do not form part of the property. The sale agreement was silent on whether the two items are a part of it. Brenda is aware that Abraham intended to have the items to be a part of the property, as he asked if these paintings and sculptures would be included in the sale of the property. To which Brenda vaguely replied that they could discuss this further if he sealed the deal immediately with her. However, Abraham said that he needed some time to think about it, as the purchase price of the property was a bit steep for him. To the facts of the case, during the finalization of the sale and purchase of the property, none of them brought up the inclusion of the paintings and sculptures. Brenda had no such intention to conceal the facts that the items were not part of the sale. In Hemp and Bygrave, the judge had examined the seller's intention, aside from taking into account the intent and scope of the annexation test. Brenda's intention was that the items were never to be included with the purchase of the property. In this present case, the paintings and sculptures are of high value, and it would be unreasonable for both the items to be included with the purchase of property. Despite the price of the property being a bit steep for Abraham, his understanding was that the purchase price was inclusive of the items. On the other hand, Brenda's argument was that common sense would dictate the exclusion of the paintings and sculptures, as they were mere chattels to the property and did not form part of the property. In conclusion, with the items likely to be chattels and not being part of the sale and purchase agreement to the facts of the case, it does not constitute as part of the property. With the intention of the owner paramount, as this aligns with the journal article, The Fixtures Doctrine, was it ever really the law, by Ronald W. Polston? Brenda's intention was only for the items to attract potential buyers to purchase the property, and it was not inclusive with the purchase of property. In advising Abraham, he can bring a cause of action under misrepresentation, arguing that Brenda's statements about discussing the inclusion of the items constitute a misrepresentation. However, he faces challenges, as it was not stated in the sale and purchase agreement. Abraham may rely on the test of the purpose of annexation by stating that the items were supposed to be included in the purchase price, as from the very beginning it was very steep for him. It is reasonable for the property to be high should the items be included. In addition, he may rely on the court's decision in Hemp and Bygrave, where the discussions influenced the purpose of the annexation, making the garden ornaments fixtures and allowing them to pass with the property, in which the defendant was stopped from denying that the items were included in the sale, thus rendering the items as fixtures, with Brenda having to sell the property with the items involved.